A very good evening to all my dear students. Once again, I welcome you all for the second session of this chapter that we are doing in corporate law, that is Prospectus and Allotment of Securities. So today we are going to learn too many things in this chapter, but before we proceed, I have planned a schedule for today's session. So first 15 minutes, we're going to have a quick recap and revision of what we have done in the previous lecture. Because children, it's a very technical topic, I know, prospectus, but we have understood few things in the previous lecture. So we'll have a quick revision of that. Then we'll be covering today types of prospectus, that is shelf prospectus, red herring prospectus, and deemed prospectus, which we have discussed in the previous class also about deemed prospectus and abridged prospectus. After that, we will be starting with the liabilities, what is misstatement in prospectus, how the criminal and civil liabilities are attracted. So be ready with your pens, papers, be ready to write down, making notes as much as possible. We're also going to cover important case laws, children, today. So it is very important that you pay 100% attention, whatever I'm going to teach you. Plus, we'll be referring to the presentation. Along with that, we'll be covering all the important case laws from the ICAI module itself. So I hope you all are ready, and a very good evening to all of you. Let me just check out your names, those who are ready with us over here. So good evening, Moruju, Niketna, Divya, Pallavi, Pranav, Tejaswin, Grahan, all those who have written beautiful evening wishes. Good evening, all of you. Sukhveer, Hima, Hardik, Yashaswini, Anirudh, Shikha, all of you, very good evening, children. So you all know that for sending the queries, now you're not using the chat box. You can send the queries directly to the admin portal wherever you have any doubts. So be ready. And also I have planned few important questions for you. We'll be testing your knowledge so that ma'am can make out how much you have learned in the previous lecture. So the thumb rule for your CA inter syllabus is that whatever we are going to teach you, you have to revise it. And we're going to test your knowledge by giving you certain questions of test. So I hope you all have revised it. Yes, Miss Bibi, Aisha, Anirudh, Neha, Avinash, Garima, Pooja, Divya, those who have just joined. Good evening, children. Good evening, all of you. Pranav, Pallavi, all of you. All right. So we have done two types of issues, that there is a public issue and a private placement. So the first question to all of you are, Moruju has written a query also. Okay, I'm just going to read it out. What are the expenses which the company need to incur to sell the existing public shareholders shares to the public? Okay, so this is related to OFS. We'll just come on that, Miss Moruju. So before that, let me just ask you a question. Can a private company go for the initial public offer? Can a private company go for the initial public offer? True or false? Good evening, Radhi Milani, Nanda, all of you. Can a private company come up with the initial public offer? True or false? What should be the answer? False is the correct answer. Very good. Ratimilani, Pranav, Divya, Afsal, Tanu, Nanda, Ranjita, Praveen. All of you have given wonderful answers. Good children. Tanu and Venkatuswav. Maina. So Mr. Maina, very correct answer. Anirudh, Pallavi, all of you. Balachandra. Because it is not listed, it can go for private placement. Okay, Tejaswin is trying to tell us that private company can only go for private placement. So this is what we discussed in the previous lecture. A public company can go for IPO, FPO, rights issue, OFS, bonus shares, and private placement for raising the securities from the public. However, private company only has three methods of raising securities, that is rights issue, bonus shares, and private placement. Private placement is section 42, which we'll be covering in our next session. All of you have given the correct answer. Very nice. So in definition of securities, we have done what are securities. So the question to all my dear students is, can we say that units of collective investment scheme units of collective investment scheme is part of securities under the Companies Act? Yes or no? What is the correct answer? Okay, Ranjita, all the PPTs will be provided to you. I will just check with the admin and we will just get it uploaded at the portal. Amar is saying no, Astha is saying no, Nanda is saying no, Afsal is saying no. So that is very wrong. That means you have not learned the definition of securities. And Aisha, Pranav, Rathimilani, Kiran, Neha, all those who have said yes is correct. Anirudh correct, Balachandra correct. So units of collective investment scheme, children. So you have to learn the definition very carefully. Units of collective investment scheme is yes part of securities because it says security include these. So that means this comes and falls under the definition of security. But if I ask you about ULIPs, then it is no, ULIPs are not part of. Why ULIPs are not part? Because here you're giving a cover for life insurance also as well as the investment also. So ULIP is not covered. Correct, Asta. That's correct. Divya has also written no. So it's yes is the correct answer for collective investment scheme and no is the correct answer for ULIPs. Okay. All right. So now prospectus, we have already done its definition. Today, we will be discussing all these big names that I've used in the previous lecture, that prospectus is a document. What is prospectus? So we are doing the chapter of prospectus. Prospectus is a document which the company takes out to the public, telling all it's about detailed information that this is my financial position, this is my objective, this is my company's profits and all the reports and financial information. It is described, a document which is described as prospectus, on the basis of which investors are going to invest in your company. They are going, it is a kind of a document. We are going to the public and asking for the money. So that is prospectus. It includes shelf prospectus, red herring, and any notice, document, advertisement which offers securities from the public. So section 31, 32, 33, 34, 35, all these sections we're going to cover in today's lecture. Section 24 is a deemed prospectus. We have already covered deemed prospectus. Section 24 simply tells you that SEBI has to regulate the issue and transfer of securities. Section 25 talks about the deemed prospectus. So what are the two important conditions? So revision is going on, children. I told you first 15 minutes for revision. So I'm asking you, it's okay, Mr. Nanda. He's writing, I heard like ULIPs. So it's okay. ULIPs is not part of securities, but I asked about units of collective investment scheme, then yes, it is part of securities. Good. Good evening, Mr. Satyam Raj. Good evening, Vaishnavi. Okay, correct. Rashmi, Pooja, all of you are correct. Okay, children. So what are the two conditions to be seen in case to call the in order to call the document to shall be called as a deemed prospectus? There were two important conditions. Can anyone tell me within how many months the allotment of securities should have taken place? And what was the second condition for deemed prospectus? So you have to tell me, in order to call it a deemed prospectus, what two conditions needs to be seen? So students who are here with us, they can also answer. Mr. Grehen, I hope all of you have the access to this admin portal. Hardik, Sukhveer, Kaur, Anirudh, you can also answer to the portal. Yashwini, Manvi, all these students. Okay. Yes, within 6 months allotment should happen. Tanu and Satyam are correct. What about others? So what is the time period? So you want me to revise this topic with all of you. So let's have a quick recap. Deemed prospectus. Allotment, it shall deem to be that it is a deemed prospectus if following conditions, either of the condition is fulfilled. Number one, securities have been offered. So you have given it to the issue house to take the securities. So what is the deemed prospectus? Where the company is trying to avoid all those headache of SEBI regulations. They have given the securities to the issue house so that they can sell it further to the public. Now, if within 6 months of the allotment, within 6 months of the agreement that you have made, the company has made with the issue house, and within 6 months allotment happens, then yes, it will be deemed that this document that they're using for offering the securities is a deemed prospectus. Or where full consideration has not been received. So if net consideration has not been completely received from the date of public offer, then it will be assumed. If any of the condition is met, then the issuing document shall deem to be a prospectus. All right. And now many of you have given the correct answer also. So wonderful. That's absolutely correct. All right, children. Very good, very good. So I'm not going to name. So many of you have given the correct answers. So wonderful. And these are the additional matters we have already done in deemed prospectus. That amount and the time and place where the agreement can be inspected should be given. So what is the provisions related to dating and signing? Then we have done contents of prospectus. So I have prepared certain questions for all of you since it's a revision time. So who shall sign the deemed prospectus? Number one question goes to all of you is who shall sign the deemed prospectus? So we have just discussed section 25. What is a deemed prospectus? Very good, Anirudh. All of you have given the correct answer. Raman, Rashmi, Niketna, Khushi Gupta. Very good. B. Kiran. Good evening, B. Kiran. Join now. So we are doing revision. Okay. So who shall sign the deemed prospectus? Director. Somebody saying directors. So what do you mean by directors? One director or two director? Bhavna is asking me to choose one, ma'am. So you are doing MCQ with me, huh? If you write such kind of answers in the exam, then what will happen? Examiner will also try to choose which is the correct one. So don't give such kind of choices. You have to tell me the correct answer. So it shall be 2 directors in case of a company and at least half of the partners in case it's a partnership firm. I told you, children, in section 25, the signing provision is very important. So here it is written, at least 2 directors. If the company through which you're offering the securities, it is a company, then 2 directors shall be signing the deemed prospectus. And if it is a partners, then at least half of the partners. Wonderful. Those who have given the correct answer, 2 directors, is the absolute correct answer. This is my test of knowledge. Yes. Now, the second question is, can the prospectus under section 26 be signed by majority of directors? True or false? The Jasmine has already given the answer for the second one also. Good. Very nice. So, a majority of directors are signing. This is the question, MCQ taken up from your ICAI module itself. The prospectus is being signed by majority of directors. True or false? What is the correct answer? Yes. Majority of directors, or it should be all the directors including the proposed directors. You want me to show you the provision as well? So the signing shall be done, a signed copy of prospectus. Every person who is named either as director or a proposed director shall sign the prospectus. Children, law is very, very easy, very simple. If you try to understand with the teacher, you grab the information, it is stored over here. But the only humble request to all of you is keep revising because the content is too much. So much of theory you have to do. It's very interesting and you will really start loving the subject if you'll keep revising. See, when you're a CA student, hard work has to be there. You know, when I ask a student, what are your strengths? When I ask any CA student, what are your strengths? I tell them that, don't say, ma'am, my strength is hard work. The moment you use the word, I am a chartered accountant student, I'm a CA student, that means it's imbibed that hard work is there in your blood. If you are a CA student, obviously you are a hardworking person. Then only you can do a CA. So it is implied. It is implied with the word CA goes very well versed with hardworking person. So for being hardworking, keep revising. See, now you must have seen your intelligence power, like you are writing 2 director, 1 director, and in prospectus, it is all the directors. So you have to be very, 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 very careful. Okay, whatever provisions you have learned, keep making notes, keep writing down each and everything. And all these kind of questions which I'm giving you for test your knowledge, they're going to help you for your examination point of view also. So keep framing questions which keep coming to your mind along with the topics that you keep covering. What shall be disclosed on the face of prospectus? Anyone can tell me that? All of you have given the correct answer and Supriya has answered this one also correctly. So false was the correct answer for the previous one. Absolutely correct. Those who have given false for the second one is correct because it shall be signed by all the directors, including the proposed directors. Yes, Miss Moruju, absolutely correct. And net amount received, the time and place, very good. We have already done. What shall be included on the face of prospectus? So here it is written on the face of the prospectus. You should include the copy has been delivered and filed with the ROC and all the documents that you have attached with the prospectus. This kind of question for 2 marks or in the MCQs, they can give you certain kind of questions. So they will give what all is disclosed on the face of prospectus. Copies filed with ROC, list of documents, point number A and B both or none of the above. So C will be the correct answer, point number A and B both. Okay. Prospectus is valid for how many days? Fourth one. It's very easy now. Correct, correct, correct. Keep moving, keep moving. So after this, we're going to start share prospectus also. Prospectus is valid for how many days? 30 days, 60 days, 90 days, or 120 days. I've given you the MCQ words. Tell me, children, prospectus is valid for how many days? Absolutely correct. 90 days from the date of issue, it remains valid, and after 90 days, it becomes invalid prospectus. Okay, so prospectus is valid for 90 days. If we're saying 6 months, see, got you. That means you have not revised. 90 days is the correct answer. Very good. All of you have given the correct answer for 90 days. What are the conditions for deemed prospectus? We have already discussed. 6 months allotment shall happen, or if net consideration is not received, then it is deemed prospectus. Now, sixth one is very interesting. What is the difference between IPO and FPO? Is there any difference, children? What happens at the time of IPO and what happens at the time of FPO? So instead of asking you questions, now I'm quickly going to give you the answers so that we completely revise it and move forward. So IPO is initial public offer. You're bringing the prospectus, issuing the prospectus for the very first time in the market. So the company is coming up in IPO means for the very first time it is approaching the public to asking them to take the securities and inviting applications. FPO is further issue of shares. Initial public offer and follow-up public offer, in which you subsequently, when you need money, the company is in requirement of money, then you are issuing FPO. So if anyone asks you in the MCQ that the company is coming up for the first time for issuing securities, is it issuing FPO? So you would say no, then it is issuing IPO. For any further or subsequent issue of securities to the public, it will issue FPO. And what is OFS? Somebody has asked a query in OFS also. OFS means offer of sale for securities, means the shareholder goes to the company and tell them that I want to sell my securities, I want to dilute my shareholding and I want to sell it to the public. So whatever expenditure company is doing, whatever things they will be issuing a deemed prospectus, all the kind of expenditure, the shareholder is going to reimburse the company. Reimbursement will be taken from the shareholder for whatever expenditure the company is going to incur in that case. And seventh one is, can we make a variation in prospectus? We have very well learned about section 27. Yes, we can make a variation. Any variation you are making, SR needs to be passed. And what has to be given to the dissenting shareholders? Can the dissenting shareholders leave? So if they find any variation which they're not happy with it, exit offer can be given to the dissenting shareholders. And who is an expert is the question which goes to the class before we move forward. So who is an expert is your last question that you all have to ask. Section 27, we have already discussed. Section 26, contents we have done. This is your variation. Section 27, where special resolution needs to be passed and dissenting shareholders. All right. Now, the last question is, who is an expert? Because again, this expert word will be coming. Very good, very good. All those who have answered all the answers correctly, well done. So, who is an expert, children? The last question for the testing of your knowledge. In chapter 1 also you have learned its definition. In chapter number 3, while doing the contents of prospectus, you have learned its definition. So expert is an important person because his statement is attached. He should have given his content that yes, the prospectus is fine and he has not withdrawn his consent. Then only expert statement shall be included. So somebody is saying expert will give the consent and CA, CMS, CMA. So again, you're giving me options. Ma'am, choose from this, whatever suits you best. Huh? So valuer, engineer, CA, CS, all these people who holding the certificate of practice so that they can certify whatever is correct to God, allowed by the law. So exact definition has to be learned by now. So please try to learn the definition of expert. All of you have given the correct hints. The words that you have chosen, it's correct, but try to learn it. All right. Now let's move to a new section, advertisement of prospectus, section 30. So children, while bringing up the prospectus, we are telling the company, telling the public about the information about the company. So section 30 is very, very simple. It talks about where you're trying to give any advertisement in the newspaper. For that, you'll be coming up with a prospectus. So whenever any advertisement is being coming, so there is a newspaper, say for example, in any newspaper, you're bringing up that my company is coming up with prospectus. What all needs to be specified, what all needs to be included, this is what section 30 is telling. So whenever there is any ad of prospectus, these 5 items shall be. Now, to your surprise, this is a very small and simple section, but many a times for 2 marks, this kind of question can also come. So again, a thumb rule, don't leave any line written in your ICAI module. Whatever is written in the study material is the Bible for you. You're not required to go outside the study material and again search for a lot of material. Whatever is given in the study material, that information is must for you. You can definitely refer to the Bayer Act. You can refer to the rules, whatever are given in the MCA website. You can refer, you can increase your knowledge, but don't try to leave anything which is given in the module. You must do each and everything from the module. It's very important. Plus, you can refer the presentation, which I have made the shortened notes for your reference, along with these, the questions that were. All right. So advertisement of the prospectus, where any ad is given for the prospectus, it says that following things shall be specified in the contents of memorandum. Number 1, object. What is the object of the company? What is the company actually in? So you're coming up with a prospectus, you're giving its ad. It's very important to tell what is the object. What is the liability of members? So liability clause, you remember in the memorandum, amount of share capital of the company. What is the liability? Name of the signatories to the memorandum. Who all have subscribed, who all have signed the memorandum of association. Number of shares subscribed by the signatories and the capital clause, that is the capital structure of the company. So all these minute details shall be given in section 30 whenever you're giving any kind of advertisement in the newspaper for prospectus. These 5 things shall be given. Let's quickly learn it. Object, liability clause, capital clause. So 3 things very easy: object clause, liability clause, capital clause. You can remember it from that in memorandum of association. Along with that, names of the signatories and the number of shares subscribed by these signatories. All right. So there are certain questions which I want to take up with you, but we'll come back to the questions. Yes. See, Kia Limited decides to issue 1 lakh securities of the company, and company has decided to publish an advertisement. Enumerate to the company about necessary contents. Now, what is it? It is such a simple question. It can come for 3 marks also, 4 marks also. He's trying to tell you that company decided to issue the securities of the company and now they're giving the advertisement. So which section will become applicable? Section 30. It is simply talking about any advertisement shall be given, what all contents of memorandum shall be specified, object, liability, capital, name of signatories, number of shares. So if my students have learned section 30, they can very well write it down. 3 marks question, 3 out of 3 you will. If you don't remember sections, according as per the provisions of the Companies Act 2013 will be good enough. But now you're in a senior class. Try to learn as much as possible about the sections. I told you when you divide your chapters into section wise, then it becomes very easy for you. So these MCQs we'll be taking up in a while. Let's move to the types of prospectus. So shelf prospectus, red herring, abridged and deemed prospectus. Deemed prospectus, children, we have already done. Now we're going to start with the first type of prospectus, that is the shelf prospectus. So what is the shelf prospectus? In fact, it is the second type of prospectus. First, we have already covered in the previous class and we have also revised it. That is deemed prospectus, section 25. Now we are going to do what is shelf prospectus. So what is the meaning of shelf? The shelf itself tries to tell you, for example, if you go to any bakery shop, you must be knowing that whenever you purchase a bread, you try to read its expiry date, because products like a slice of a cake at a bakery shop or pastries or butters, bread, all these have a very short span of life. So that is called a shelf life. So you go to the baker and you ask him, the pastries are kept on the shelf. You tell them that is it fresh, or and if the shelf life is over, means if they're expired, they try to replace it. They try to throw it when they're expired. So shelf means a shelf life we are talking about. For how long there is a validity of certain thing. So this is what I'm trying to tell you in a layman's language. What is the shelf life? So what we have to remember for a shelf prospectus, whenever I go to eat a pastry, I have to see whether the shelf life of the pastry is still there, or is it valid, or it is expired. So if it has expired, again, if I purchase a bread, it is 14th October today. If it's say used by 14th October, I will not purchase it because the shelf life is over. Okay, so validity of the period, basically whether it is valid or it has expired. This is what we understand with the word shelf. So now, ma'am, what has the prospectus to do with this shelf life? That is what we're going to understand. Shelf prospectus means a prospectus for the securities which are included for subscribing of one or more issues for a certain period of time. Now, what happens, children? Shelf prospectus comes out with a validity period. Shelf prospectus is issued by a companies for a validity period of 1 year. Now, what happened? There are certain companies who feel that again and again we will be issuing multiple securities to the public, and it becomes very, very difficult for the company to come up with a new public issue every time. Every time they will be coming up with the prospectus, they will be complying with the SEBI regulation, so it becomes very difficult for them. So where a company is trying to come up with the multiple issues over the period of time, then it decides to issue a shelf prospectus. So where the company wants to raise money from the public multiple times during the same year, then it issues a shelf prospectus. So once the prospectus is issued, it remains valid for 1 year period. Now, again and again, after 2 months, it can raise the money. It can ask for the money. After 6 months, it can ask for the money on the basis of same prospectus that I have filed with the ROC. There is no need to issue fresh prospectus every time. Let's take an example. For example, a company has issued on 1st of, say, 17th January 2023, company has filed shelf prospectus with ROC for a period of 1 year. It has filed it with the ROC. Now it has come up with the first, every time for the first issue of securities, you have to file the shelf prospectus whenever you come with the first issue. Now the company on 25th of April again wants to issue the securities. Now what will it do? It will use the same shelf prospectus. Once I've given you the information, it remains valid for 1 year period. It does not have to come up with the prospectus again. Now, children, you have to tell me one thing. It issued shelf prospectus on 17th of January. On 25th of April, it is again requesting the public for the money. It wants to expand its business, want money from the public. Don't you think that there has been certain changes in the financial position of the company? Company has already issued a shelf prospectus. It has told about what is my company's objective, how the money will be raised, what all securities I'm coming up with, and each and every detail has been given. Now it is coming for the subsequent offer of securities. So whatever changes have taken place in the financial position of the company, whatever more charges have been created against its company's assets, certain charge has been created. What is the meaning of creating a charge? Means company has taken loan from the bank or borrowings and mortgage has been given against the company's assets. So certain charge has been created against company's asset, any financial position has been changed, or any other information as may be prescribed has to be informed to the public every time you come up with the subsequent issue in case of shelf prospectus. Now, ma'am, you just now told us shelf prospectus will be coming for the first time only and it is valid for 1 year. Now, how am I going to tell the members, public about my changes in the financial position? So, I will be issuing another document, that is IM, Information Memorandum, which will show up the changes in the financial position of my company. So, all these financial position changes in the financial position of the company, charges created, any additional charges, new charges created against the company's assets, or any other material as may be prescribed will be written in the information memorandum. And this shelf prospectus, along with the information memorandum, shall become my deemed prospectus. It shall deem to be the prospectus issued to the public. First time I'm offering the securities, I will come up with the shelf prospectus. I have to file it with the ROC for the first time. It remains valid for 1 year period. Further and subsequent issues, there is no need to issue fresh prospectus every time. So don't have to comply with lot many things again. I simply have to issue a document, that is information memorandum, which will specify all my changes in the financial position and any new charges created in the assets against the assets of the company. So shelf prospectus, children, is a very convenient method for regularly issuing the securities. If company is issuing shelf prospectus, who shall issue shelf prospectus? Only the SEBI will notify the companies. So only SEBI notified companies. Please write it down in your notes. Only the companies which have been notified by SEBI, companies notified by SEBI can issue a shelf prospectus. Everyone will write down only the companies notified by SEBI shall issue a shelf prospectus. So it is a convenient method. Regularly means company, again also write down in your notes, please children, where the company wants to raise money, from the public multiple times. All these small notes, all these abbreviation helps you to remember and learn. Where the company wants to raise money from the public multiple times, then it can issue a shelf prospectus. So number one, it is a convenient method. Number two, multiple times. Number three, it shall be specified. Only the SEBI notified companies can issue shelf prospectus. Number four, no need to issue fresh prospectus every time. Number five, shelf prospectus shall be filed with the registrar at the time of first offer. So on 17th January, I was bringing the first offer, and on 25th April, I'm bringing the subsequent offer. So what is the date in which I have to file the shelf prospectus? Tell me, children. On 17th January, I bought a fresh first time offer of securities, and 25th April, I'm bringing the subsequent offer. What time I need to file the shelf prospectus? And what time I need to give the information memorandum? Tell me, hurry up. Okay, just shell about the shelf prospectus as 17 January, absolutely correct, because that is the date when I'm coming for the first offer of securities, and multiple times I'll be raising money. 17 January is the date when I'll be issuing the, is the date of offering the security. So I shall file it with the ROC. Very good. Number 6, it has a shelf life and is always available for the public to view. So the shelf life, the pastries which I have kept on the shelf of the store, it is available for the public to view. Similarly, shelf life prospectus. So children, you must have seen whenever you apply for admissions in your certain colleges and schools, you always try to see the prospectus. It is always lying on the reception area. You must have seen when you go for any college admission or you go from taking any interviews, the prospectus of the company is lying over there. So that is a kind of shelf prospectus which anyone in the public can come and view it. They can see what kind of achievements the organization has made, and what is the actual status and how they have been doing, how many admissions have happened, how the organization is running, all these kind of things, so that it helps you to take a decision whether you're going to take admission in that respective college. Similarly, prospectus is providing you full hand information about the company to the investors so that they can decide whether I have to invest in this company or not. So all these kind of shelf prospectus along with the information memorandum, it is trying to tell you that information memorandum will give all the current facts changes in the financial position. That this was my first issue of securities, this was my net profit. Now it might be saying that, remember variation in the prospectus section 27? I told you whenever any variation is made, any changes are made, we give the exit offer to the dissenting shareholders. Similarly, here also we will give the right to the shareholders. Say, for example, if I am a shareholder in your company and you have issued a shelf prospectus and you gave me a very nice, glorious figure of your company when at the time of first offer of securities. And I was so happy that I gave you advance money for the subsequent offer also, that this company is going to keep coming for the multiple issues. I am giving you my advance money. But the moment you came with the subsequent issue and you raised this information memorandum, you circulated this information memorandum. So it is the duty of the company to give me the information memorandum, because, say, for example, I am shareholder Mr. A, who has already given you advance money for the subsequent offer also on the basis of your shelf prospectus. So now company will send this information memorandum to Mr. A, telling them all the material facts and changes that have happened in their financial position of the company. So if I am Mr. Shareholder, Mr. A, I did not like these changes. I thought the company will be doing very well or company will be quickly expanding, but the expansion is not as per my expectation. Then I can tell you, I can again get dissenting shareholders. Remember the word I told you, naraz ho jana. I can tell you that I'm not happy with your financial position. I want my money back. Can a shareholder do that? Yes, he can. If he's not happy seeing your financial position changes in the information memorandum, he can ask for the refund of his advance money given. And within how many days the company is supposed to refund that money? Within 15 days, amount has to be refunded. For the subsequent issue, any advance that he has received has to be refunded within 15 days. And let's complete it. First, we'll move on point by point. Advance, again, I will be explaining you this point. So share prospectus is valid. Number 6 point, it is valid for 1 year and commence from the date of opening of first offer. You have already mentioned 17 January, the example. No prospectus required for subsequent offer. An information memorandum is filed in PES2 form 1 month prior to the fresh issue. So if I am bringing my subsequent issue on 25th April, so 1 month prior means before 25th March, I should give you 1 month prior to the every fresh. So 1 month prior to 25th April. So within 25th March to 25th April, 1 month prior. So 1 mahina pehle, I have to give you the information memorandum so that these prospective investors who are thinking to take more shares, they can take a decision whether they want their 15 days money back or they want to take up the securities. So there are 3 important dates, children, that I want you all to write it down separately for section 31, share prospectus. Number 1 date is, it is valid for a period of 1 year. Number 2 date is, information memorandum shall be issued 1 month prior to every fresh issue. And what is the 3rd date? Within 15 days, a refund of advance money shall be given. Please write down these 3 important dates. It is valid for 1 year and has to be given 1 month prior to every first issue. Within 15 days, refund of advance money. Have you written? Let's move forward. Ms. Bhavna, within 15 days, they can demand their advance money as soon as they see the information memorandum. From the date when they have requested for the return of the money, within 15 days, the money shall be returned. So this is the provision. Any applicant remitting subscription money shall be intimated. So I told you that example you can apply over here. Mr. A, who has already given me the advance money, he shall be intimated about the changes. You will send the information memorandum to Mr. A, telling them about the changes in the financial position. They have the right to withdraw the application and the company will refund all the money received within 15 days. Information memorandum shall deem to be part of prospectus. Very important point you have to remember. Shelf prospectus along with the information memorandum shall deem to be the prospectus. Write it down in your notes. Shelf prospectus along with the information memorandum. So Anirudh, refund is available as and when the shareholders feel that they're not happy, they can withdraw the application. So if they have given the advance money, then only they will be withdrawing the application. If I have not applied for your shares previously, then there is no question of refund of money. So as and when they have given, they can demand for the before the subsequent issue. It is valid for 1 year. So within 1 year period, this kind of things can happen. So company has to refund all the money received within 15 days. So there is a question for you. Prakhar Limited intends to raise share capital by issuing, even for debentures, we can issue share prospectus. Again and again, if the company is issuing debentures, then the share prospectus can be issued. Company intends to raise share capital by issuing equity shares in different stages over a certain period of time. Now, how you have to find out the question relates, now it has very clearly given different stages over a certain period of time. So, yahan se we can figure it out. It is talking something about share prospectus. Company does not wish to issue prospectus every time. So, companies like us only, it doesn't want to go for again and again. SEBI is a very big body. You have to do so much of compliance for SEBI. So it says one time I will do it once and for all. For 1 year at least, I'm relaxed. I can issue in different states. So considering the provisions, discuss what formalities need to be done to avoid repeated issue of prospectus. So which section will become applicable, children? What is it talking about in the first question? It is talking about shelf prospectus, section 31. Examiner can ask you a question like this, or it can straight away ask you what is shelf prospectus and what are the important provisions. So if such a kind of creamy question comes to all of you, you have learned the 3 important dates. So you simply have to write shelf prospectus, you give its definition, you give its the stages, how it is given. You have to mention about the validity period, underline whenever you give such kind of things in the exam. 1 year period. For subsequent, you're not issuing prospectus. Other things are you're filing the information memorandum, telling about the changes in financial position, and it has to be given within 1 month. Within prescribed time means within 1 month prior to the issue. Then that means company has to comply with the above provisions and can issue a shelf prospectus. Whatever points we have discussed in my notes, this is the theory that I've written over here. You can write down in notes also for learning. It becomes easy when you break up the points in notes and you try to learn. Now, before we move to the red herring prospectus, let me take you to the study material also. And also, I'm going to show you a copy of shelf prospectus. This is how children's shelf prospectus looks like. Mahindra Finance, I have downloaded for you, Mahindra and Mahindra Finance Services Limited. So they have come up with the shelf prospectus. So this is how the shelf prospectus looks like. It is written shelf prospectus. The date shall deem to be the date of the prospectus. Company was incorporated in Mumbai. Certificate of incorporation, ROC has been filed. Registered office is given. All of the details are given. Who are the promoters and this kind of things. So you don't have to read it. But one thing I want all of you to notice over here is that it has written public issue company for up to rupees. It has come up with 2 crores unsecured redeemable non-convertible debentures, and the amount has been given. So this is a shelf prospectus where the number of shares and the face value price is given. After a while, I'll be showing you another type of prospectus, that is red herring prospectus with certain incomplete information. So just look at this prospectus. Nobody in the exam is going to ask you, make a prospectus for us or what kind of prospectus is it. This is just for practical knowledge since we're discussing the topic. So you can just have a look. Mahindra Finance has issued a shelf prospectus in 2017 and this is how the shelf prospectus looks like. Now it remains valid for certain period of 1 year, not certain period. It remains valid for 1 year and they can bring their subsequent issue. So it's a very long prospectus whenever the company is issuing a prospectus, children. It's a very long prospectus, around 300 to 400. Some companies might have 300 pages, some companies might have 500 pages, because the detailed information about the company is given. And the investors have to read it very carefully because you're going to give your money to the company. You're taking the shares and investing money in the company. So it is very important to read the prospectus very carefully. But for small shareholders, like for example, if I just simply want to buy 1500 rupees, 1500, I want to invest in Reliance, or 5000 rupees shares I want in Reliance, then it becomes very difficult. It is so difficult. I'm just investing 5000 rupees and I'm reading these 500 pages, such a big prospectus. In that case, we can read a short summary of a prospectus, which is your third type of prospectus, which we'll be doing today. That is abridged prospectus. Okay. Okay, before that, let me show you certain things from your study material. We have covered everything from the study. We will keep saying study along with this. So this advertisement part is clear. Shelf prospectus, it remains valid for 1 year period. This we have done. Validity is given. So all these points, subsection 1, 2, I have broken down in points. You can write down in your study material also point 1, 2, 3. So it says a company filing a shelf prospectus is required to file information memorandum with the registrar prior to the issue of subsequent offer. So when shall the company file the information memorandum? The question to all my dear students. Yes, we'll see all the type of prospectus today. Miss Moruju, a shelf prospectus we have seen. Then I will be showing you red herring prospectus. Then I will show you prospectus also. All this is there today for you. Yes, children, I have asked you a question. I have highlighted over here. Prospectus company is coming up with a shelf prospectus and it has to file information memorandum. What is the time period when the company shall file the information memorandum with the ROC? Dilip has given the correct answer. Afsar, Rishita, Pranav, Tejaswin, Pallavi. What about others? 1 month prior to the fresh issue is the correct answer. So good. That means you're paying attention. And what all changes have to be shown? All material fact, new charges that have been traded, changes in the financial position, and as may be prescribed wale changes. Now, here is your subscription advance money. It says company or any other person shall intimate the changes. If they express to withdraw their application, then they shall refund all the money received within 15 days thereof. So when they tell that we are not happy, return their money. And what form has to be used? So all the information from the module has been covered in those notes. You can simply break down in notes and remember. So rule 10 is telling all these kind of things that PS2 form has to be used and 1 month prior to the subsequent issue. And what is the name prospectus? Information memorandum along with the shelf prospectus shall deem to be prospectus. So now the question for all of you, MCQ, an applicant who has made the application for allotment along with the advance payment, if he wants to withdraw his application after the changes made in IM, the company will refund the money as per board's discretion. Don't cheat the answer from your module. Pay attention on the screen. Shall refund the money after deducting administrative charges. Certain charges have to be deducted. Refund the money within 15 days or after deducting the administrative charges within 30 days. Please choose the correct option A, B, C, D. So all my dear students have already given the answer. C is the correct answer. See, did we talk about any board directors? No, we did not mention anything like that. Did I tell you any charges to be deducted? Did I tell you 30 days? So simple answer is within 15 days. Now this B point is just to confuse the students. They start thinking any administrative charges. We have not learned any such thing. Just go what is written over there in the app. It simply tells you that money has to be refunded within 15 days. That's it. Simple. So बस जितना पढ़ा है जो याद करा है वो लिख देना है. Money has to be refunded within 15 days. That's it. Is that clear? Now, all of you are geared up for red herring prospectus, another type of prospectus coming in front of you. So before we start reading your herring prospectus, I'm going to show you a copy of red herring prospectus of Nykaa. So Nykaa, all the girls buying Nykaa products. So Nykaa has recently issued red herring prospectus 1st August 2021. So prospectus shall always be dated when we studied about the contents of prospectus, and draft red herring prospectus will be updated upon filing with the ROC. And can you read what is written? Please read section 32 of the Companies Act. So they are trying to tell you, my dear chartered accountant students, what you're studying is published over there, section 32 of the Companies Act, such an important section. It is talking about the red herring prospectus. So it is a kind of a draft prospectus before issuing the final prospectus. Many companies, it is an option given to them. Many companies choose to bring a red herring prospectus. 100% book built offer means it is a kind of method used for determining the price of securities. I want all of you to pay attention. What is the difference between red herring and shelf prospectus? Shelf prospectus, I told you multiple times you're coming for the securities. For 1 year, you have issued shelf prospectus. We have seen Mahindra Finance shelf prospectus. NICA, I'm showing you red herring prospectus. Red herring prospectus have two important information missing in its prospectus. Number one is the quantum of the securities, initial public offering of dash equity shares. We don't know how many equity shares. Face value of ₹1 each, and then they have not told you at a price of rupees dash per equity share. So the information related to the quantum of shares, that is number of shares, and or it can be and or the price of the share is missing in a red herring prospectus. Red herring prospectus is one of the incomplete prospectus where the number of shares and price is missing. Now, man, then what is the need of bringing this red herring prospectus? Suppose there are two cosmetic companies. One is NICA, which is into retail kind of thing, not just into cosmetics, it is into many other things as well, for clothing also. So there are two companies, company A and company B, which are into the similar kind of, say, pharmaceutical industry. Now, company A has already bought its IPO, and they have created that, they have told that this is the IPO at which we are coming, and the investors know that now we have to read this prospectus and invest in the company. But company B is trying to create a hype about itself. It said, okay, company A has come up with the prospectus. Let me come up with a red herring prospectus. It's a kind of, what is the meaning of red herring prospectus? Like, for example, before a movie is released, what comes up before a movie? A trailer comes up. So a trailer tries to tell you that these are the actresses who will be working in this movie, and you should go and watch this movie. And also they're trying to do promotion. So it is a kind of red herring prospectus, is a kind of trailer which is released before releasing the full picture. So you have not given the complete information. You have just written, this is the total share capital that we'll be raising. We do not know how many shares we'll be bringing and at what price. So that is what red herring prospectus is all about. It is just trying to create a hype among the public that we are also coming up with a prospectus. We are just trying to attract the investors. Now, company A has already come up with the prospectus in the pharma industry. Company B came up with the red herring prospectus. Hey, listen, before you buy the securities of A company, we are also there in the queue. We are also coming up with the prospectus. You can think of investing in our company also. So red herring prospectus is also going to give you the detailed information about the objective of the company, financial position, how it is going to use your money, and each and every detail financial, all the section 26 contains. But it is a red herring prospectus, which is an incomplete prospectus, where number of shares and the price per share will be missing. So we have also created a hype about red herring prospectus. Now let's understand what is it all about. So company does not, it is a prospectus which does not include complete particulars. So Moruju, you were asking me difference between prospectus and red herring. This is the major difference, that red herring prospectus is incomplete and prospectus has the complete information. Very good, Ashutosh, Tanu, Niketna, Nanda, Niveta, Afsal, all of you paying wonderful attention, and I'm glad you're enjoying the session. All right. So red herring prospectus means a prospectus which does not include complete particulars regarding the quantum of securities or their price. Company proposing to make an offer may issue red herring prospectus before the issue of prospectus. Now, red herring prospectus comes prior to the issue of prospectus. So before you issue the prospectus, you are coming up with the red herring prospectus. And how many days prior? It shall be filed with ROC at least 3 days prior to the subscription list and the offer. So red herring prospectus have to be brought into picture. So another thing I want to tell you for red herring prospectus, see, for example, you want to buy a new car for your family. You're thinking to buy a new model of Kia car. You know, Kia is very in these days. If it's your favorite car or any other favorite car, Creta or whatever you want to buy. So what will you do? You'll simply go to the showroom and he will say it's for 13 lakhs or this model is for 18 lakhs. You'll simply buy it. What will you do? Won't you do a survey in different showrooms? You'll try to see the price in different showrooms, and you'll try to see the car in different places before finalizing, before paying the price money. Similar is the case with the company. It is coming up with an IPO. It is showing up you the complete information, but it is not showing you the quantum and price of securities. It wants you to determine book building method, the method of discovering the price of securities. So how much hype will be created? How many people are going to subscribe? How will the shares will be taken? On the basis of them, total share capital divided by the number of shares, we will determine the price per share. So here they are going to tell you about who are the promoters, how the business operations of the company will be done, what is the profits, what is the liability, balance sheet, all 400 to 500 pages. Detailed data will be given in the rate hearing prospectus. Only two things are missing, that is quantity of shares and price of shares. Children, in red herring prospectus, company will also tell you the purpose for which the money is going to be used, entire detailed financial position along with the purpose. So the draft red herring prospectus is made and it is filed with the registrar 3 days prior to the fresh issue. Before coming up with a fresh issue of the securities, they will file up the red herring prospectus with ROC. Now SEBI will check all the draft red herring prospectus. What is the abbreviation that we use for it is RHS. RHP, sorry. Red herring prospectus. It will check the red herring prospectus and after approval from SEBI and stock exchange, the draft prospectus will then become the final prospectus. They will check whatever rate is becoming and same obligations as of the prospectus will be given. So number one, quantum and price is missing. Number two, it is issued prior to the issue of prospectus. Number three, at least 3 days prior to the issue of prospectus, you have to file it with the ROC. Number four, it carries the same obligations as the prospectus. And number five, any variations in the prospectus. Now, this is your red herring prospectus that you bought, and this is your final prospectus. You have taken the approval of SEBI, ROC filing, everything has happened. Now, any variations, any changes that have happened in the red herring and final prospectus, that shall be highlighted as variations in the prospectus. Whatever changes, whatever variations have happened, now you have determined the closing price. So once you have determined the closing price, now it will become the price and quantity is clear. Now it will become the final prospectus. So that is how your final prospectus has been declared from the red herring prospectus. Now, whatever variations between the red herring and the final prospectus, they shall be highlighted as the variations in the prospectus. Upon closing of prospectus, I'm talking about prospectus, not red herring, the main prospectus, the total capital, closing price, and other details which are not included shall also be filed with the ROC and SEBI. So upon the closing of offer, before closing the offer, you have to give the final details about whatever were not included in the red herring. Now you have to file the same also with the ROC and SEBI. Okay, children. So ROC red herring prospectus does not include important information. The company wants to raise the money from the public. It has to file the ROC 3 days prior to it. Here we are trying to find the price of the securities. It is a book building method. RHP is sent to qualified institutional buyers. These are the finance companies. So basically it is sent to the finance companies, banks who are experts in the field of stock market because we want to know what kind of quotations or price that will be given for our shares. It is basically in case of IPO, you are trying to use this in order to find the price of securities. Investors must read red herring prospectus carefully before taking up the share in the company. Now, why does it say so? Because you are going to invest in the company. So it is very, very important that you read each and every detail about the red herring prospectus and on the basis of it, the final prospectus will be coming after taking all the approvals from SEBI and ROC. Is that clear? So let's take a small break over here. After that, we have still lots and lots to finish today. We'll be doing abridged prospectus and huge liability topics will be taken up. Let's take a small break here. Meanwhile, just go through shelf and red herring prospectus. further. So are we connected? All right, welcome back, students. So we have already done red herring and shelled prospectus. Now let's move to the third type of prospectus, that is abridged prospectus, section 33. So I was telling you earlier that instead of reading 400 to 500 pages, if I just want to invest rupees 1500 or 3000 rupees in Reliance, so it becomes very difficult. I would not even read the prospectus. I'll just take an overview and I'll just take the information from others and I will invest my money. This is what happened for a general everyday shareholder or the investor. So law says for such kind of people who are just investing, small investors, they don't need the complete information. There is a summary memorandum, that is abridged prospectus, is also known as summary or condensed prospectus. A summarized prospectus is issued for investors like us who want to invest small money in a company so that they can avoid reading the detailed prospectus and they can just go through the summary. Now, this summary shall give all the key details about the features of the company, silent features. So remember, day one, the first definition given under section 2, subclause 1, abridged prospectus is a memorandum containing silent features. Silent means important features of prospectus as may be specified by SEBI by making regulations on this pair. Every share application shall be accompanied by abridged prospectus. So basically, abridged prospectus is a summary of a prospectus. Because it is very difficult to read the entire detailed prospectus, so a brief summary is prepared in the abridged prospectus, and every share application form shall go along with the copy of abridged prospectus. The only exceptions are for underwriting agreements and when there is no public offer. And if anyone asks for the full copy of prospectus, it shall be given to them. Say, for example, if I'm subscribing to the shares of the Reliance and I've seen the abridged prospectus, now I want to see the full prospectus also, I can request for this full copy of prospectus. So it says every share application form shall go along with the shares or debentures. Every share application or debenture application has to be accompanied with the abridged prospectus. And this is not applicable if there is a bona fide invitation to a person to entering into underwriting agreement. So in case of underwriting agreement, abridged prospectus is not required. Where the offer is being made to existing members means what is it talking about? It's talking about rights and bonus issue. If you're making the shareholders your rights issue only, existing shareholders, you're offering the shares. So they already know about your company. Now, why will you issue a prospectus to them? So if the existing debenture holders or existing shareholders to whom you are giving the offer, then there is no need of abridged prospectus. When the shares and debentures are not offered to public, means you're doing a private placement. In case of private placement, you don't have to issue the abridged prospectus. And in the case of underwriting agreement. Now, what is the case of underwriting agreement? Underwriting agreement means where I'm entering into the agreement with the underwriters. They have said that, okay, we'll take the bulk shares from you and we'll get the minimum subscription for the company from the public. So such kind of agreements, when we're entering with the underwriters for the shares and debentures, we're not offering directly to the public. We're giving it to the underwriters who will be offering the money to the public and then giving us the money. Sale and purchase of share is happening through the underwriting. So in this case also, abridged prospectus is not required. When the shares are not offered to the public, it's a private placement case. When it is a private placement case, then also the abridged prospectus is not required. And when you are making the offer to the existing members, then also the abridged prospectus is not required. Number one, with every share application has to go. Number 2 point is the exceptions that you have to learn, children. Number 3 point, on request being made by any person before closing, full detail of the prospectus has to be issued. So if I have invested in your company and I want to have the full prospectus also, then the company has to furnish the full prospectus also. Suppose I'm seeing the abridged prospectus of ABC Limited and I said that, okay, this company really seems to be interesting. Before closing of the subscription list, I demanded for the full prospectus, then I should get the copy of full prospectus also so that I can take a wise decision for the investors. Point number 2 done. Point number 3 is very interesting. Default in this case is company shall be liable for 50,000 rupees for each default. Now say, for example, a company has issued 80 share application forms. And with 10 application forms, it forgot to attach the copy of abridged prospectus. I told you that with every share application form, it has to go abridged prospectus. And with 10 share applications, it forgot to attach the abridged prospectus. Now the penalty will be 50,000 rupees for each default. So 50,000 for one share application not attached, and for 10, so the total penalty will become rupees 5 lakh rupees. So 5 lakh rupees will be the penalty if any default is made in complying with the abridged prospectus. All right, so this is the penalty which is given in case of abridged prospectus. For each default, it is 50,000 rupees. All right. So if 10 application forms went without abridged prospectus, then 50,000 into 10. If 6 only went, then 50,000 into 6. Okay. So let us see the same from the study material also once. Any doubts so far, children? If you want to ask any doubts, because after this, we will be starting with your misstatement in prospectus. You can raise hands if you have any doubts. All right. Red herring prospectus, we have completed. It is something which does not include complete details. We have already done this. Let's take the important questions from here. So book building is a price discovery method. Somebody was asking, means it doesn't fix a particular price. Instead, it gives a price range. So price range is given accordingly. They will decide what price has to be taken according to the book building. So examiner can ask you which kind of prospectus has this book building offer. So can you tell me, is it shelf prospectus, red herring, or a bridge prospectus? Book building is a price discovery method. With which prospectus this word goes? With shelf, red herring, or abridged prospectus? Tell me, children. You have to answer me. Yes, P. Kiran. 3 days prior, that is the correct point that you have written. So with which it will go, children? Tell me. Very good. Red herring prospectus as the book building method. Tejaswin, why are you writing a abridged? It is red herring prospectus. So Priya, correct. Mr. Nayan, we just discussed according to the priority, it will be issued the type of prospectus. Bhavna, what did you not understand in a abridged prospectus? We're just going to revise that only. So abridged prospectus, she's asking, it contains the silent features of the prospectus. Who will specify? The SEBI will specify. So abridged prospectus is a summary of the prospectus. So instead of full-fledged prospectus, you're just giving the summary. It is a summarized form to cut the cost involved in the publication of large number of prospectus. So along with the share application forms, instead of issuing all of the prospectus along with that, you just give the summary copy. It is application which is whenever you're having underwriting agreement, shares offered not to the public means only to the existing members you're offering, or you're doing private placement. So in point number A, you can write down underwriting agreement. Abridged prospectus is not required. Point number B, you can write down private placement. Abridged prospectus is not required. Point number 3, you can write down, for example, rights issue when you're just giving to the existing members. Abridged prospectus is not required. And when demanded, then full copy shall be made available, and 50,000 rupees fine has to be there. Anyone wants to ask any doubts till here? Yes, Mr. Nanda, you can do that. You can issue the red herring prospectus is optional. It is not compulsory for the company to issue. Yes, Hardik, you can unmute and ask your doubt.
Ma'am, good evening, ma'am.
Good evening.
Ma'am, like in penalties, we have seen that usually there is an upper limit. But ma'am, if there is no upper limit, then it is continuous.
Yes, then that is the amount that they have mentioned will be taken as the penalty amount.
So ma'am,
There will be certain situations, Hardik, where you will be having limits set up. Like we'll be moving to section 447 in a short while. There's a limit which is set up. According to that, your penalty would be. But if the amount figure is given, then you have to use that.
And ma'am, I have one more doubt from the previous class. Ma'am, in offer for sale, we have seen a box where there was minimum subscription and minimum application value. Ma'am, I was not able to understand it. Can you please explain?
Okay. So those things which minimum subscription, it is not applicable, minimum application, it is not applicable. Those 2 points you're getting confused. So don't worry at all. Section 39, when we do, it is in detail about allotment of securities. There you will understand what is the meaning of those terms. So
Okay,
just
ma'am.
wait for the third session, it will get clear.
Okay, thank you, ma'am.
Welcome, Beta. Yes, Sanya.
Hello, ma'am.
Hello, Beta.
Ma'am, isn't there any liability under Section 32?
Section 32, red herring prospectus, no penalty has been given.
Okay, ma'am.
And it is optional also, okay?
Okay, ma'am.
Okay, yes, Pooja. So, Sanya, for penalty for misstatement and prospectus, it is applicable to all the liabilities. Children, be very clear. Section 34, 35, 36, 37, 38, which we are going to use, they are totally for the penalty and liabilities. If you do any misstatement, even in red herring prospectus, then you will be liable to 34, 35. Okay? But like the way it has been given specifically 50,000 for abridged, it is not mentioned any specific. Yes, Pooja.
Ma'am, I want to know about red herring prospectus. मैम क्या मैं हिंदी में मतलब पूछ सकती
Yes,
हूँ?
yes, you can ask in Hindi, no problem.
मैम अगर किसी चीज का प्राइस ही नहीं दिया है ना, ये दिया है कि कितनी क्वांटिटी में मतलब शेयर परचेज करना है, कितने प्राइस का, तो फिर मतलब कैसे डिटरमाइन होगा मैम कि मतलब
Okay.
ये इतनी
I'll tell you,
क्वांटिटी
just mute
प्राइस है? ये
yourself.
रेड हेरिंग प्रोस्पेक्टस थोड़ा सा हिंदी में बता दीजिए कैसे क्या
Okay,
है.
हिंदी में बता देती हूँ, हिंदी में बता. Mute yourself, Pooja. So she wants me to explain red herring prospectus in Hindi. So I am telling for all those who have written in the query also. Pooja, mute yourself. So red herring prospectus basically means जब आप, I told you कि मूवी आने से पहले आप एक ट्रेलर रिलीज कर रहे हैं, आप कस्टमर्स को, पोटेंशियल इन्वेस्टर्स को अट्रैक्ट कर रहे हैं कि हम भी एक प्रोस्पेक्टस लाने वाले हैं. I told you there are two companies, company A and B in the same pharmaceuticals industry. Now A has already come up with the IPO. They have told that this is the share and this is the price per share, and we are coming up with the initial public offer. Company B thought that okay, let me also create a hype about my prospectus. Even I am coming up with the prospectus, so it issued 3 days prior to the first opening issue. It issues a draft red herring prospectus. It has filed with the ROC that look, I am also coming up with the issue. बट टू इंपॉर्टेंट फीचर्स, इसमें दो चीजें इंपॉर्टेंट है जो मिसिंग होती है. हमें ये नहीं पता कि कितनी पब्लिक हमारे शेयर्स को सब्सक्राइब करेगी. हमें टोटल शेयर कैपिटल का अंदाजा है, फिगर है, बट हमें प्राइस नहीं फिक्स करना आ रहा और हमें अपने नंबर ऑफ शेयर्स नहीं पता. तो हम कोटेशन लेना चाहते हैं, हम देखना चाहते हैं मार्केट में हमारी कंपनी का क्या रिस्पॉन्स आता है और उसके बेस पे हम अपना प्राइस डिटर्मिन करें. सो ये बुक बिल्डिंग मेथड कहते हैं, प्राइस डिस्कवरी करना. हम पब्लिक से जानकर हम उसका प्राइस, जैसे आप मूवी रिलीज होती है तो उससे पहले हम ट्रेलर दिखाते हैं कि ट्रेलर देखकर लोग कहते हैं भी हाँ यार इस मूवी में कौन सा आपका फेवरेट एक्टर, हूसोएवर रणबीर कपूर आ रहा है या पंजाबी मूवीज में दिलजीत आ रहा है, सो डेफिनेटली ये मूवी हम जरूर देखने जाएंगे, हमें अच्छा लगता है. सो हाइप क्रिएट करना. इसी तरह से रेड हेरिंग प्रोस्पेक्टस एक हाइप क्रिएट कर रहा है मार्केट में कि कम आप ए के पास तो जा ही रहे हो, उसने अपना प्राइस बता दिए. आई एम ऑल्सो कमिंग अप विद प्रोस्पेक्टस. कंपनी बी विल से I also have something new coming up for you. Please wait for my prospectus also. So my IPO also, and accordingly we are just trying to public को attract करें अपनी तरफ. ठीक है पूजा? All right. So हिंदी में red herring भी हो गया. Now Shahid, you want to ask something?
गुड आफ्टरनून मैम.
Good evening.
मैम मुझे इसके बारे में पूछना था. आर्बिट प्रोस्पेक्टस में जो पेनल्टी का दिया हुआ है, अ कंपनी इज लायबल टू पे पेनल्टी ऑफ 50,000 फॉर ईच डिफॉल्ट. मैम कैन यू एक्सप्लेन डिफॉल्ट मीन्स व्हिच काइंड ऑफ डिफॉल्ट्स?
Okay. So Shahid, for abridged prospectus, I told you with every share application form, आप एक copy of abridged prospectus दो. अब मैंने 100 share application forms, उनमें से 10 application forms के साथ मैं कंपनी हूं और कंपनी abridged prospectus लगाना भूल गई, तो एक डिफॉल्ट हुआ. एक शेयर एप्लीकेशन के साथ आपने शेयर abridged नहीं लगाया तो 50,000 पेनल्टी. 2 के साथ नहीं लगाया तो 50,000 इंटू 2 1 लाख. अब 10 के साथ नहीं लगाया तो 50,000 इंटू 10 5 lakh penalty मुझे भरनी पड़ेगी, because you're telling the potential investors to invest in your company, but you're not giving them the summary of prospectus also. So if you're issuing a bridge prospectus, is the summary which has to go with the every share application form. So if it is missing behind the share application form, penalty for that default will be 50,000 for each default that the company makes. All right, Pooja, you still want to ask something?
यस मैम। मैम
Is it
एक्चुअली
clear?
ये तो मुझे समझ आ गया कि ये बुक बिल्डिंग के लिए होता है, लेकिन मतलब कैसे पता चलेगा? जैसे हमने क्वांटिटी भी नहीं बताई कि कितनी क्वांटिटी के शेयर, मतलब कितनी क्वांटिटी हम देना चाहते हैं, और हम प्राइस भी नहीं बता रहे हैं कि कितने प्राइस का हम शेयर दे रहे हैं, तो कोई क्यों खरीदेगा? मतलब ये थोड़ा सा बता दो मैम, ये
Okay.
समझ नहीं आ रहा मेन
Oh,
कॉन्सेप्ट
okay,
ये
okay.
है।
Don't worry. So, see, number one, we don't have to go into too much detail about how it will happen. You know, a prospectus is very interesting chapter. The more and more we study about it, we try to go into much nitty-gritties and details about it. But at the same time, we have to remember, children, that we have too many sections to revise also, to complete also. So we, first of all, we will not be going into much detail. There are different companies who are issuing prospectus. एंड ये आप सिर्फ रेड हियरिंग में आपने ये समझना है कि कंपनी को नहीं पता लग रहा है, वो नहीं देख पा रही है, इट्स अ न्यू कंपनी, इट इज कमिंग अप विद एन आईपीओ, उसको नहीं पता कि मेरी कंपनी में प्रोस्पेक्टस में आप क्या दे रहे हो, फाइनेंशियल पोजीशन बता रहे हो, ऑब्जेक्टिव बता रहे हो, सारी डिटेल्स दोगे आप कंपनी के बारे में, तो इन्वेस्टर स्टडी करेंगे, आपस में डिस्कस करेंगे, दे विल सी, आपको एक रिस्पॉन्स ले रहे हो आप पब्लिक से कि कितना हमें कैसा रिस्पॉन्स आएगा, उसके बेस पे हम अपने प्राइस को डिटर्मिन करें. Up how it is doing, we can explain. Why it is doing is the motive of determining the price. That is why red herring prospectus is coming. According to SEBI and Companies Act, all the rules and regulations have to be complete. So if you go into much details, then it will go into very, very detailed. So simple, this much only you have to remember as per your slips. Okay. So B. Sai Kiran, yes, you can unmute yourself.
Madam, this red herring prospectus, you are telling before the issue, 3 days
Okay, go
before
slow,
they have
go
to
slow, go slow, go slow. Yeah.
You are telling the red herring prospectus to be filed with the registrar within before 2 days, 3 days of the issue.
3 days.
Then
back.
regular prospectus, when it will come?
So once we have finalized before closing of the price, when we have determined the price, then your final prospectus will come. And any variations, now if you have issued a red herring prospectus, you have filed it 3 days prior to the fresh issue. So your fresh issue is about to come 3 days before that you have given the red herring and all this hype has been created. And now before closing the subscription, your final prospectus is coming in the market. So whatever
Not
variation,
at the opening of the issue, na? Not at the
Yes.
opening of
3 days
IPO.
before the opening of the offer.
No, madam. 3 days before opening the issue, red herring prospectus will come. That is okay. But when the IPO comes, when the prospectus will come, before or after?
After, always after. Prospectus will always come up. Okay.
So IPO will go without prospectus.
Sorry?
IPO will start without regular prospectus.
Yes, with the regular prospectus, definitely.
How it will be, madam?
All right.
That is, that
Yes?
is, please explain. That is, please explain the timelines and all for regular prospectus.
Okay, we'll just take it up in a while. Let me just speak to Rashmi also. All right? Yes, Rashmi.
Yes, ma'am. Good evening, ma'am. I have doubt regarding before IPO, company required to issue 3 type of prospectus: सेल्फ प्रोस्पेक्टस, रेड हेरिंग और वो ब्रीज प्रोस्पेक्टस. पर जो 3 टाइप का एक्सेप्शन है ब्रीज प्रोस्पेक्टस, अगर वो अलाउ होगा तो हमें रिक्वायर्ड नहीं है ब्रीज प्रोस्पेक्टस ऑफर करने के लिए.
Okay, mute yourself, I tell. So, ब्रिज प्रोस्पेक्टस हम बात कर रहे हैं रश्मि समरी की. जब आप शेयर एप्लीकेशन फॉर्म के साथ प्रोस्पेक्टस की एक समरी देना जरूरी. प्रोस्पेक्टस की कॉपी तो आप दोगे ही दोगे. ओके, प्रोस्पेक्टस तो आपका पब्लिश होगा ही, तभी आप आईपीओ के लिए लेकर आओ. सेम थिंग दैट द प्रीवियस चाइल्ड वाज आस्किंग साइचर, कि अगर आप prospectus will come when at the time of IPO prospectus will be issued to the public, and if that person also who has read your abridged prospectus, if he demands for the prospectus, then you have to give him the copy of prospectus. The only thing is red herring comes 3 days prior to the fresh issue. You are determining the price. Share prospectus is having a validity period when you have to come up with the multiple times of prospectus. So any of the document, that's why what is the basic definition of prospectus? Any of the documents that is described as prospectus is known as prospectus. It is including shelf, it is including red herring and any advertisement which is given to attract the public to invest in your company. That's why I've shown you different kind of prospectus also. That is for a validity period, you're issuing share prospectus. Before issuing the fresh prospectus, you're creating a hype in the market. Then you're coming up with a draft red herring prospectus. All right. Okay. Yes, Hardik.
Ma'am, one small doubt. Ma'am, we know that red herring prospectus, we have to go through a book building process. And in book building process, usually this is issued to QIBs, HNIs who will subscribe it and tell us the demand. But ma'am, for example, if they do not create any demand, then we will not release the prospectus, no?
Yes, if there is no demand, then you cannot issue the prospectus. If you suppose you have not got any demand. So RHP is sent to qualified institutional buyers finance companies who have fields quotation just for taking the quotation for the price of the shares. So if you
Yes.
have no demand, then obviously you'll not be coming up with the prospectus. Then there's no need of coming up with the prospectus, right?
Okay. Thank you.
All right, good. Yes, Bhavna.
Ma'am, what is the meaning of bona fide?
Bona fide means for the benefit. Okay.
And ma'am, who issue abridged prospectus?
The promoters who are going to issue, they will be issuing the abridged prospectus. The company's directors, promoters, any other person who is authorized in the company, they will be issuing the prospectus. Abridged is the summary of the prospectus. It is just the
Ma'am?
brief summary containing all the key details about the company.
Ma'am, is there any need and of SEBI guidelines या SEBI notification for issue the abridged prospectus?
Everything in the prospectus has to be taken care by SEBI. Okay? SEBI regulations have to be followed, but nothing specifically for you to learn in case of this. Simple, whatever we have done. We have covered the material, prospectus, abridged prospectus. You learn the definition, you learn the exceptions, and this penalty of default and 50,000. And the fourth point, if any request is made, full copy shall be given to you. Also, we'll be covering certain question answers also, so it will get more detailed and it will be more helpful for all. But we'll do that after doing the misstatement. Yes, Kiran, quickly, last question, and then we'll move further.
Ma'am, self prospectus is mandatory or not?
Shelf prospectus
Self
is
prospectus.
okay. Kiran, if your company is not coming up with the multiple issues, will you issue shelf prospectus? Tell me. So you have answered it? Yes or no? Tell me at least.
Yes.
Then
yes.
you'll not issue.
Yes,
Then you'll
ma'am.
not issue. Right? Okay. So misstatement in prospectus. Let's move further. Section 34 and 35, liabilities. Now, this is very, very important section. Misstatement in prospectus. Now, I want all the eyes and ears paying attention over here because we are doing something which is very important and we'll be going into much detail. Still, if you feel, we will be doing a quick recap and revision also of shelf and red herring prospectus. Still, agar koi doubts rahe jayenge, you want to ask anything, I'm here beyond the time also. So don't worry, okay? Don't worry. But pay attention towards the misstatement also because it is very, very important. All right. Let's do this misstatement. Yes, Mr. Nanda, then only the penalty will come. Okay. Tambeshwari, you can ask your query a little later also. I did not understand 4 prospectus explained short word. You want me to explain them in shortly, so we'll do it after the syllabus is done for today, okay? Okay, so the golden rule of prospectus always says that there's a golden rule for the prospectus that the prospectus should give true and fair picture regarding the company's financial health. Prospectus should not contain any untrue statement, any suppression of material facts, or omitting any material information which is affecting the decision of the investors if it is having any untrue. Untrue means false. What is the meaning of false? Jhoot bolna. You're lying. If you're making any kind of lie in the prospectus, you're giving false statements in the prospectus. You're suppressing any material fact. You were supposed to disclose something important. You have not told it. You have suppressed it. Suppress means हिंदी में छुपाना, hide करना. Suppressing means to hide important information. Omits means fails to tell, fails to disclose. Please write down all these meanings. Untrue means false. Suppress means to hide the information from the prospectus. You have hidden something. Something you were supposed to disclose, you have suppressed. You have hidden that material. Omits means you fail to disclose. So suppress and omission can be understood very clearly when you are trying to give incorrect or incomplete information. You're not giving the true picture of your company's financial health, financial position. You're using false statements. Then the prospectus is said to be misleading. It is said that there is a misstatement in prospectus. Hence, section 34 will get attracted. Section 34, children, talks about your criminal liability. You have created a crime. Why? Because investors are investing relying on your prospectus. You are coming up with a shelf prospectus, red herring prospectus. You are including any kind of wrong statement in any of these prospectus. You, directors, promoters, and every person, those who have authorized the prospectus, will come liable for penalty under section 447. Where there is any intentional mistake, please write down in your notes. When the company is trying to do any intentional mistake, this word is important, child, intentional. Intentional mistake, trying to create a fraud, then section 34, criminal liability, will come in picture. When the mistake is intentional, you are जानबूझकर, intentional हिंदी में मतलब होता है जानबूझकर. आप एक गलत statement दे रहे हो. You're giving false statement in the prospectus. What is the meaning of false? You went to the market and your mother told you to buy only 10 chocolates. You purchased 15 chocolates and you came home and you tell your mom that I've got 10 chocolates. Did you lie to your mom by saying that? So you have given a false statement. झूठ बोलना, lie करना. So company is giving false statement. I'm having a profits of 100 crore rupees. Actually, the profit is 1 lakh rupees. So you're giving a false statement. Criminal liability. 447 will become applicable. Very, very dangerous section is coming. Okay. Suppress the material facts. You were supposed to disclose the details about all your associate companies, holding and subsidiary. You're hiding it. You're not telling it. Or you fail to give. You fail to disclose it. You have not given the complete information. Section 34 will get it right. So what are the 3 important words? Any untrue statement, false. Any suppression of the material fact. Material fact, the information which is material has not been told. So for example, you have written the name of the promoter was Harleen Kaur and you have written the spelling. It is Harlen. You wrote Harlien. So this is not a material mistake. How does it make a difference? So you're just making a spelling mistake in the name of the promoter. That is not something material mistake. That is not affecting the decision of the investors. Any material mistake that you have made which is affecting the decision of investors, please write it down. Intentional mistake, fraud, which is material in nature. And it is affecting the decision of investors. Then only section 34, criminal liability, will become applicable. So it is very, very important that each and every information that as children, you already have so much information given in the book. I to restrict your minds and yourself till that. We enjoy going beyond the book also because it is very interesting. And when you come up with your queries and you ask, ma'am, how it is happening, why it is doing so, I enjoy taking those queries. But if you go into much detailed discussion about that now, then time will be gone. That is the thing. So we have to keep in the mind your time, your syllabus, and your coverage also. So all these things. But even once we are done with the syllabus, still if something is coming up in your mind, you can ask me, relax. You can ask me, I'm there to help you. Okay. So misstatement is any intentional mistake, fraud, and which is material in nature, and it is affecting the decision of investors. Then section 34, criminal liability, will come into picture. Now let's discuss a very, very important case study. What happened in case of DLF company? So there was a company, DLF company. It came up with the prospectus, and at the time of issue of prospectus, when they came up with the IPO, they filed the prospectus with ROC. I told you you have to file a copy of prospectus with the ROC. And it failed to include the name of its associate company. Now, children, section 26, you have done with me contents of prospectus, all the financial information reports as per SEBI guidelines and Companies Act has to be given. So it is also important that where you're disclosing your financial information, all the details information about your group companies also have to be disclosed. So this was the company which failed to disclose the name of its associate company. I might be the investor in your company. I want to know the entire information. Who is your holding? Who is your associate? Who is your subsidiary? So here you have omitted some material information, something which is very important for the investor to take the decision, and you have done that intentional mistake. Even if you have done by mistake, it is considered to be company has failed to disclose the name of its associate company, means company has made the prospectus misleading. What is another name that we are using in case of misstatement? Misleading. आप misguide कर रहे हो public को. You're not telling them, you're not giving the complete information who is your associate company. So here you have created a material misstatement in the prospectus. What will happen? Section 34 became applicable in this case of company, and all the directors and CEO of the company were disqualified for 3 years. So they reissued the prospectus, they corrected all the mistakes, and they had to reissue the prospectus. Investors went to the court and they said, see, there is a material misstatement in the prospectus and company has done this mistake. So it was held, this is a misstatement, and they had to correct this thing. So this is basically trying to make you understand what is the meaning of omitting the facts or suppressing the material information. These kind of mistakes will make the prospectus mistake or misleading. Now, what is the defense that the directors can use? Now, defense means, हिंदी में क्या कहते हैं? नहीं, मेरी गलती नहीं, मैंने जानबूझकर नहीं करा. ठीक है ना? अगर आपकी कोई गलती होती है, मिसस्टेटमेंट क्या है? गलती है, आपने मिस्टेक करी है, सेक्शन 447 लायबल हो जाएगा. बहुत भयानक सेक्शन है. 447 is a very huge penalty which is coming up on the company now. All the directors, promoters, all those who have signed, authorized the prospectus will come under the preview of this. So it is very dangerous. So they can take shelter. Law says section 34 says, okay, criminal liabilities under section 34. If you have done any untrue statement, any misleading, any false, any suppression of material facts, golden rule says everything has to be correct and fairly disclosed. If you have done any such mistakes, you are going to come under section 34. But section 34 will not be applicable. What defense you can use, what protection you can use, if the person, director, proves that the information which is omitted or suppressed was immaterial and it is not influencing the decision of investors. Like I just told you that name of Harleen ma'am was to be given as director. Instead of using this word Harleen spelling, you have used HARLEI. So it is not affecting much of the changes. Okay, na? Provided there is another director who is with this name with another company, then it can be material. So you have to prove. The burden of proof lies on the directors that, okay, fine, this is the thing that I'm saying and I'm honestly saying this. So the information, let's understand another example which is given in your study material also, office address. So there was a company, they have given the office address of the registered office that, listen, we have the registered office in Delhi. They have given this information at the time of IPO. It came up with the prospectus and it has informed that we have the registered office in Delhi, but it fails to tell you that we have one office in Chandigarh also, or one office in Bangalore also. It failed to tell you this. Now, how come this information is affecting the decision of investors? You have given full disclosure about the registered office address and everything. If you have one more office, it is not going to impact my investment decision. No? So if you have opened up another branch, so it is not. So if you have failed to disclose this kind of thing, if you fail to mention that there is one more office in Chandigarh, then this is an immaterial information. इतना ज़्यादा इससे कोई नुकसान नहीं हो. Immaterial means इतनी important information नहीं. Those who want are writing me, ma'am, Hindi में बोलो, please, for those. Immaterial means something which is not very important. So if you have omitted or suppressed, which is immaterial fact, then it is not going to be, then that defense can be taken. Just let me give 1 minute to me. Sorry, students. My health is little low today, so please bear with me. Okay. So where the information is not very immaterial, it is not very important, and you have omitted that information, then it's okay. It's not influencing the decision of investors. Directors can take this kind of defense. And second is where they had the reasons to believe that information was true and they continue to believe it is true. Now here we have taken the example of office address. One of the office address is failed to disclose, then it is immaterial. Immaterial means not important. It is not influencing the investor's decision, then it's okay. You had the reasons to believe that information was true and continues to believe that. So you knew that the company is, whatever the company is saying, it is saying it truthfully. It is not saying anything false. Now, how will you say that? You have relied on the audit report. Say a company is relying on the auditor's report. Who will sign the auditor's report? A chartered accountant. A professional has made the audit report. He has signed it. So now company has taken that audit report, and suppose there is some error in this audit report. Now that CEO will only know that whether there's an error in, I am a company, I have just taken the audit report from you and I'm relying on that information and I have given that audit report in my prospectus also. Now, if there is such kind of error in the audit report, directors can prove, they can tell that we have relied on this audit report, we have the evidence, we have this audit report also with us to prove our point that we thought that this information is correct and we still continue to believe. Till what date? Till the final issue of the prospectus, we continue to believe that whatever is given over there is true. So they have to prove this point. The burden of proof lies on the people who are making this kind of statements that number one, the information that has been omitted or suppressed is not material. It is not influencing the decision of investors. And number two, we had the reasons to believe that the information which was given was true. And we have relied on that information and he continues to believe that it was a true information. In that case, it will not be considered as the mistake on behalf of the directors and promoters, whosoever are. All right. So I hope this is clear. Let's move further. So what happens with section 35? Before we jump to section 35, I want to take up study material also because there is many details given in the misstatement. Now, this is your at most good faith. Somebody was asking about this at most good faith, the bona fide. Bona fide means that it is a doctrine of at most good faith, a contract for the shares. Whenever you're having the contract for the shares of the company, that means you're buying it in the at most good faith. Purchasers are entitled to true and correct disclosure of the facts. You have to tell them the true facts about the company. Your prospectus, the golden rule of the prospectus says that you have to give the true and correct disclosures. You cannot hide anything from the prospectus. Scrumptious accuracy. Okay, what does it say? It means with honesty, you have made prospectus shall make all the statements which are true. Neither any information which requires for the public to be concealed or omitted. You should not make any kind of wrong, false statements. And you should not make any kind of untrue and wrong impression statements. Now, as per section 34, a statement included in prospectus shall deem to be untrue if the statement is misleading and inclusion or omission of matter is likely to mislead. Means either you have made a misleading statement, you have given a wrong statement, you have included any untrue statement, or you have given a statement which either you have included something which is misleading or you have not included something. Those who are writing on the portal, there are certain queries which are coming over here also. Students, let me complete this topic and then I'll be answering you. Okay. You have written certain queries over here, but let me just complete this topic first. Okay. So inclusion or omission of any matter which is likely to be misleading. So let's see certain case laws which have been given over here. Rex versus Kylsen. Now what happened in this case now? A company was paying regular dividends. Now what happened? There was a company, Rex versus Kylsen case law we are going to discuss. It says there was a company and it gave its prospectus that we are paying regular dividends to our shareholders. Now, children, you tell me one thing. You have to answer me. If a company is paying regular dividends, and that means the company is very profitable, profit hoga, paisa hoga, tabhi company is paying good dividends. What will you think about that company? You will think good about that company, or you'll think bad about that company? You tell me. Okay, let's make it a little simpler for you. I know it's a little difficult. B. Kiran, doctrine of Abridged fights. It's about the life insurance and insurance. When you talk about the insurance contract, this kind of doctrine is used. It's a Latin word. It means at most good faith. Whenever you're doing a contract of such kind, you have to be of the trust and confidence. This kind of contract has to be made. Good faith means vishwas ka rishta. Company, you are going to take up the shares in a company, so company should be honest towards you. Okay, so that is the meaning of contract of good faith. So tell me, children. Only Rishita and Nanda has answered, ma'am. Yes, we'll think good about the company. Company is giving dividend. What about others? Yes, Tejaswin, Pooja, Supriya, good. Yes, Maruju, investors will file a case if there is misstatement in the prospectus. That's correct. Section 35 will talk more in detail about it. Good, Ashutosh. Let us got issued 1 month already. Distribution 3 days, 5 10. Yes, Avinash, that is absolutely correct. But you have to issue the red herring prospectus 3 days prior to the fresh issue. Very good. Tejaswin has written, ma'am, book building is price discovery according to its demand. That is absolutely correct. Garima, Neha, Pooja, Supriya, all those who have written, yes, ma'am, the company is in good position. That is excellent. So company is paying the dividend. That means company is actually into a very good position. But what happened? Company over here failed to disclose. I'll give you certain more facts over here. Company was paying dividend. But company failed to disclose the source of dividend. From where it is paying the dividend, it failed to tell you this thing. It has not disclosed from which sources it is paying the dividend to its members. Actually, the company was in losses. It had accumulated losses and it was paying dividend out of reserves created. Out of reserves. So it was using funds of the company for paying the dividend, not actually the profits. So children, please tell me, are you doing any kind of misleading statement in the prospectus? Do you think that they have tried to hide certain things? You're not telling the source, you're paying the dividend out of the reserves, you don't even have profits, your accumulated losses you're having, and you're telling in your prospectus that we pay dividend to the shareholders. So you all tell me, yes, ma'am, it's a good position. This is what investors will think. Those who are asking, ma'am, who will file the case? Obviously, investors will file the case. Why will the director go and file a case against the company that, yes, I have issued a wrong prospectus, please file a case against me? The potential investors who are investing on the misleading statements are going to file a case against you. Okay? So, yes, very good. Those who has written. Rishi Pandey is asking, is issuing red herring prospectus compulsory? So, last time I'm telling all of you, red herring prospectus is optional. It is not compulsory. Okay? Bhavna, we are doing Rex versus Carlson case only. Please pay attention. We are discussing the same case now. Okay. So here you have omitted the material facts. Please listen to the facts once again, those who have missed it. Number one, company was paying dividend. It has written this line in the prospectus. That means company is showing a very good, glorious, nice financial position of the company that it is paying dividend. But company failed to disclose the source of dividend. Actually, the company was in losses. I've written on the screen for all of you. Actually, the company was in losses. It was paying dividend out of the reserves and surplus created. That means company is trying to mislead the investors. And there is a misstatement. And it is a material misstatement. Therefore, Section 34 became applicable to it. So the company was actually into losses. Let's read it out what is written over here. Company was actually into losses and they used to write back some of the past provisions and it was held prospectors did not disclose the true picture. So whatever facts I have given to you Abhi right now in the summary, you can go back in the video, write it down. The case law will become easy for all of you to remember. Okay. And there are other case law reference also. You can read them because you can read this one also. Directors and their friends have subscribed large portion of the capital and now they offer to the public remaining shares. Actually, the directors have subscribed only 10 shares, which were held and misleading. So Henderson case also, it has given prima facie of the facts. If the facts are not clearly given, then also if you are not disclosed, you are hiding the material information, then the prospectus become misleading. One of the case law Rex versus Kylsend, you can learn that. It's very simple. You can give an example reference also in your paper. So one case law is enough for you to remember. But you should read all the things that are written over here. So what are the remedies available? Now, this is very simple section. It is trying to take you to the Indian Contract Act. It talks about your misrepresentation. You remember, children, Indian Contract Act, misrepresentation, where you're giving a misleading or false statement, you're omitting a material fact, it amounts to misrepresentation. And what is the rights available to the agreed shareholder? What does the contract become? First tell me that. Fatapat say. Indian Contract Act, where the contract, where the consent is not free by coercion, undue influence, fraud, misrepresentation. In case of misrepresentation, the contract becomes what? Let me see how many of you remember. Bhavna is saying no fault made by company in this case, ma'am. Why? You are not telling the fact. You are just telling that the company is paying dividend. You are hiding that the company is into losses. Please tell now that company is into losses and then we are paying dividend. Then it will be a complete information. They did not tell this thing, child. They did not tell that company is into losses. They simply said the company is paying dividend. They were trying to create a fake good position about the company. Dilip, Rishita, Nanda are the first one to answer. Ma'am, contract becomes voidable. Very good, children. So the contract becomes voidable on misrepresentation. And what remedies are available? You can resign the contract and you can claim the damages. Compensation, section 35, we will be studying in detail. Any other person who has been authorized to issue the prospectus, criminal liability under section 34 and damages for deceit will arise. So all these are relation to your Indian Contract Act. You have read these words over there, damages, receipts, recession, how the damages are computed, ordinary damages, special damages, everything over here, which is written along with the Indian Contract Act, read with the Special Relief Act will become applicable. So just this much table you can read from here, nothing very important, but you can move forward to section 35. To claim compensation. Now, what is section 35 about? Section 35 tells you that if any person has subscribed to the shares on the basis of misleading prospectus, then who will be held liable? So the people who have invested on the basis of misleading prospectus and have suffered loss can claim the damages. So we are just going to come on it in a while, but just see this also. Purchase the shares on the basis of prospectus which was misleading. So what provisions will become applicable? He will have to resign the contract. Aapne sabne answer kara abhi. Contract becomes voidable unless it remains valid, unless it is actually decided. So what is the meaning of voidable? You can either end the contract or you treat it as valid. When you end the contract, you can also claim the damages compensation under section 75. Okay. But when the right to rescission is not available, then you cannot resign the contract. Means when resign means to end the contract. Children, those who are asking the meaning of rescission forgot Indian Contract Act. The rescission means resign the contract means to put an end to the contract. Okay. Deceit means to cheat, Mr. Nanda. Rescission means to end the contract. Okay. But right to resign the allotment of shares will not be available to the subsequent purchasers of shares. Very, very important thing is coming up. What is the meaning of subsequent shares? I would like to use a whiteboard over here. Let me see if I can have whiteboard. Provided you will not disturb if I try to use a whiteboard, okay? Okay. So here we are trying to see what is the meaning of. See, everybody has started. Okay, leave it. I'm not going to show you on whiteboard. Very bad students. You're all grown-up students. Why do you do like this? One is primary market and another is secondary market. Do you know what is primary and what is secondary market? Tell me. Tell me what is primary market and what is secondary market. When you have taken up the issues, when you have subscribed to the issues at the time of IPO, company has come up with an IPO and you are taking up the shares. That means you are purchasing the shares directly from the primary market. But when you take up the shares from the stock exchange, the shares have already been listed on the stock exchange and you buy the shares from the stock market, means you're buying from the secondary market. Now, what happened? There was another very, very important case law. Peak versus Gurney. Peak versus Gurney and EY. What happened in this case law? There were two investors, X and Y. There were two investors, X and Y. Okay. There was Mr. X and there was Mr. Y. X already knew about the misstatement in the prospectus. There was the company came up with an IPO and there was misstatement in the prospectus and X knew about the misstatement. So X knew about the misstatement, therefore he did not buy the shares. Pay attention, listen each and every word that I am speaking and I am writing. At the end, we're just going to approach to the end, children. I'll give you 10-15 minutes for the queries. Pehle sun lo what I'm trying to say. Primary market, when you're buying the shares at the time of IPO. Secondary market, when you're buying the shares from the stock exchange. Peak versus Gurney, there were two investors, X and Y. X knew about the misstatement and he didn't buy the shares of that company. Y didn't know about the misstatement and bought the shares from IPO. So when he bought the shares from IPO, which market he has bought the shares? Means he has purchased from primary market or secondary market? Quickly tell me. Why didn't know about the misstatement and he purchased the shares from the IPO only? Dilip and Bhavna are only answering. What are the others? Nanda, Mr. Nanda, Ms. Pooja, Rishita, Supriya, where are you all? Garima, answer me quickly. What will you say in this case? Whether it is the primary market or secondary market where you have purchased the share. Very good. Now you all have answered. So around 200 answers for primary market. Excellent. So that means you have purchased the shares from the IPO. That means primary market. Now, why? And now X did not purchase the shares from IPO. Later on, he purchased the shares from Y from the stock exchange. Purchases from stock exchange from Y. So that means now he is buying from the secondary market. And you know, then what did this Mr. X does? He says he goes to the court and files a case. Look, here there is your misstatement in the prospectus. And I would want to hold the company liable to pay me the damages. Law said, wait, did you buy the shares from the primary market at the time of IPO was issued? You did not buy the shares from that. Now, since you have purchased the shares from the secondary market, company can deny from its liability. Company will not be held liable because you have not directly purchased the shares from the primary market. Okay, so this is what he's trying to tell you over here. You can right to resent is not available. That means now you cannot end the allotment of shares if you are the subsequent purchaser of shares from the market. If you're buying the shares subsequently from, if you're primary market, you're buying the primary shareholder, then you can file a case that there is a misstatement. But Mr. X and Y, two investors, X was aware of the misstatement. He did not buy the shares from the primary market. Y purchased the shares. Y files a case, then it is valid. But X is now purchasing from Y in the secondary market. Later on, he went to file a case that, look, there is a misstatement. Then he cannot file a case because in case of subsequent purchase that you're making from the stock exchange, this is not valid. A subscriber to the memorandum cannot seek any relief as the company cannot be considered to be existence when he has appended his signatures to the MOA. So if you are buying the shares on the basis of MOA, it cannot said to have been influenced by any statement. So MOA Again, you don't have any right to rescind on the basis of memorandum of association. Let's read this example, then it become more clear. And Peak versus Goodney is again going to come. I'll explain you in detail, don't worry. All the statements in the prospectus issued were literally true. Company has paid the dividend for a number of years. There was no disclosure the dividend. अभी जो मैंने आपको समझाया that the dividends were paid out of released capital profits and not trading profits. Allotment wants to avoid the contract and the prospectus was false. Now what happens? Non-disclosure on the fact that the dividends is a concealment of material fact. You were asking Bhavna why the company is being held liable. So here it is written, you are trying to conceal the material facts. You're trying to hide the material facts. It is normally required to distribute dividend only from the revenue profits. Under exceptional, it can be. Hence, a material misrepresentation has been made. Allotment can avoid the contract. Okay. This example was on the basis of the previous discussion that we have. So what are the rights to damages? Fraudulent misrepresentation. The person should have acted upon it and suffered a damage. Now, when does Section 35 come into picture? Section 35, first read my notes from the presentation. Section 35 says, a person has subscribed to the securities relying on the misleading prospectus. The person should have suffered a loss or damage. Then what is the punishment? Then every director, promoter or the expert who has authorized the issue of prospectus shall pay compensation to every person who has suffered a loss or damage. What happens? Mr. A is the investor. He relied on ABC Limited. There was a company. It has issued a misleading prospectus. It has omitted any statement, disclosed any facts. And Mr. A, the investor, he invested in the shares of this company. At the time of IPO, he has invested, so from the primary market. Now, what happens when your prospectus is not telling a true and fair picture? There can be financial risk and financial losses to the investors, and it also damages the company's image. So here, Mr. A purchased the shares on the basis of misleading prospectus and suffered a financial loss. Damage has happened to him. Now, what is applicable? Section 35 says punishment will be given to all the directors, promoters, experts, and all the people who authorize the issue of prospectus, means all the persons who were involved in such prospectus of ABC Limited, they will be punished. They will pay compensation to Mr. What will they do? They will pay compensation to Mr. Now, defense to be used. How they can say that we are not liable? Now, directors will say, look, Mr. A, I am not held liable. How will you prove that point? In criminal liability, what were the 2 points of defense? You had the reasons to believe that the statement was true, auditor's report example. And the second one that we have done, that the information which was omitted was not very material, like my names, spellings, or the office address. What defense you're going to use in case of Section 35? A director says that I have withdrawn my consent to act as director and prospectus was issued without my consent. So there was a director, Mr. D, who was also being held liable. He said he went to the court and he proved all the points. The burden of proof lies on the people who are making the above points. So he said that Mr. D said, look, I have this written consent. I have withdrawn my consent that I'm not going to act as a director and prospectus was issued without my consent. Then this director will not be held. Number 2, director were not aware of the facts and he withdrew his consent. A director saw that in prospectus you are writing such things. I'm not even aware. What are you writing? And he quickly gave a public notice in newspaper withdrawing his consent. Look, I'm not party to it. I'm not director. जैसे ही उसे पता लगा कि ऐसे फैक्ट्स हैं जो कि मिसलीडिंग है, उसने न्यूज़पेपर में ऐड दे दी कि आई एम विड्रॉइंग माय कंसेंट. He came to know and he withdrew his consent by giving a newspaper public notice. Then he will not be held liable. Or he tries to prove that I have relied on the expert statement. उसमें auditor's report example लिया था हमने. Here, director saying I have relied on the expert statement. That expert was a competent person. He has given the written consent and he has not withdrawn his consent. And I am relying on his expert statement. So I should not be held liable. If all these points are given, then the defense can be used for Section 35. Then directors, promoters, experts who have relied on these points, who have made these points clear, will not be held liable. And on whom shall this burden lies? The burden will lie on these people to prove. And if it is proved that it was made with an intention to defraud, then they will become personally liable. So one side you are telling them that, look, I am not liable for this. It was done without my consent. But if it is proved vice versa, then all these directors, promoters will be held personally liable. I'll take a 2 minutes break over here, and at 8:15 to 8:30 we'll still continue. Just go through what we have done, and let's take 5 minutes small break over here. All right, students, let's continue. So section 35 is clear to all of you. And Mr. Nanda is asking where it is given about the defense. So where it is written child exceptions means this section is not applicable if you try to prove these points. And similarly, for if section 34 exceptions is given, means where you try to prove these points that information was which is hidden is not material and you had the reasons to believe that it was true, then it is not applicable. So exceptions में दिया हुआ है, चाहे उसे आप defense कह लो, चाहे आप exceptions कह लो. So this is your misstatement liabilities under section 34 and 35. Number one, let's do this table and then we will cover the content from the study also. Number one, criminal liability. Every person who has authorized the issue of prospectus punishable under 447. What are the defenses available? Information, immaterial, reasonable. Civil liability. Who all are liable in case of civil liability? Tell me. Section 35. What does it tell you? You have to answer. It's time for you to answer. I want to do certain MCQs also, children, with you. Tell me, children, who all are liable in case of section 35? Every director, proposed director, promoter, everybody who has authorized the issue of prospectus. So if examiner asks you any question related to liability, you can give section 34 and 35 both if you feel that in case of complete liability has to be given. And what will they do? They will pay compensation to the investors. And what is the defense that you can use? He has withdrawn his consent. He believed that it was 226 of section 5 is about your expert statement. And without his knowledge, if it has been issued, then he can give a public notice. Okay, bacha? So this is your liability for misstatement. Please learn it, revise it nicely. And now, very, very interesting section. Section 447. Now, what will happen? What is 447 about? Let me make you understand what is this. This tells about the liability in case of fraud. Those who are asking the meaning of deceit, deceit means you are trying to make someone believe which is not true. धोखा देना, ठीक है ना? धोखा देना, चालबाजी करना. डिसीट का मतलब होता है चालबाजी करना, चालाकी कर रहे हो आप उस बंदे के साथ. सो अगर आप प्रोस्पेक्टस में डिसीट कर रहे हो, इन्वेस्टर्स को बेवकूफ बना रहे हो, गलत बोल रहे हो, झूठ बोल रहे हो, उनको ऐसा विश्वास दिला रहे हो कि ये सच है जो कि सच नहीं है, तो उसका मतलब होता है डिसीट करना. ओके, so that means you're trying to create a fraud. So criminal liability means where fraud is coming up in case of section 447. What is the punishment for the fraud? So first you have to remember there is a limit which is given for section 447, children. The limit is 1% of the turnover. Now keep writing down what I'm explaining you, okay? There is a limit set up for fraud, 1% of turnover or rupees 10 lakh. 10 lakh rupees, whichever is lower. 1% of turnover or rupees 10 lakh, whichever is lower out of them. Now, if your fraud is, number one point is, if your fraud is above this limit, the fraud that you have done is above this limit, then you have two options. Number one is jail for 6 months, which can go up till 10 years. And is very important, children. And means both. So there will be a jail which can go from 6 months to 10 years and fine which is 3 times the amount in 3 times of the amount in whatever is the amount of fraud, 3 times of. If the fraud is 1 lakh, 3 lakh. If the fraud is 3 lakh, 3 threes are 9 lakh. 3 times of the amount involved will be the amount of penalty that you have to pay. So be very careful tomorrow if you open up a company and you're thinking of issuing a prospectus, never include any false statement. False तो वैसे भी नहीं होना चाहिए ना. हमारे basic ethics क्या कहते हैं, moral values क्या कहती है, हमें कभी झूठ नहीं बोलना चाहिए. We should never lie. So if you're trying to lie, you're trying to cheat the public, and where public interest is involved, more harsh the things will be. Number one, fraud is above this limit. 2 options, jail for 6 months to 10 years and fine is 3 times. And if public interest is involved, public at large is involved, then the jail will be 3 years to 10 years. It can go up till maximum 3 years of disqualification. Means you can go to jail for 3 years and the fine remains the same, that is 3 times of the amount. What is the second type of fraud? If the fraud is below the limit given, then it will be jail up to 5 years or fine up to rupees 50 lakhs. So here the amount is not very high. So there is no question of public interest or both. So this is how you have to make a very nice chart of section 447. Liability for repayment of debt, any person found guilty of fraud. So it is not just for section 34-35. Wherever 447 is mentioned, here is your liability for punishment for fraud. Because in CA Foundation, when I used to teach you about Companies Act, about incorporation also, we used to read 447 will become applicable. There I told you that in CA Inter, we will talk about what is 447. So 447, number one, a limit is set, 1% of turnover of rupees 10 lakh, whichever is less. If the fraud is above this limit, then 2 categories, public interest is involved, not involved. If it is involved, 3 years to 10 years and fine of 3 times. If it is not involved, 6 months to 10 years of jail and 3 times of the amount. If the fraud is below this limit, then jail up to 5 years or fine up to rupees 50 lakhs, or both can be made applicable. Is that clear, students? So I have certain questions for you, which I believe we will have to take in the next class, because there is certain things which are left from the study material also. So we have already done. So somebody was asking, ma'am, where are the defense given? This is the defense, beta. Exception. Exception to liability means the defenses, misstatement and reasons to believe. And then we have done this question also, damages for deceit. I just explained you, deceit means where you're trying to make other person believe it is something not true. Person responsible for issuing the prospectus, section 19 of the Indian Contract Act, misrepresentation is governed by it. This remedy is available by way of rescission. You all know about that. So how will you claim the damages? There should be a fraudulent misstatement. He is the original authority, means he has purchased the share from the primary market. He has been actually deceived means uske sath dhoka hua hona chahiye. Hindi mein, he has been actually deceived means he should have been cheated. Then only you can claim the damages. So this is your Peak versus Gournay. As promised, I'm going to explain you once again. Gournay issued a fraudulent prospectus. No shares were purchased by Peak at that time. So Peak did not purchase the shares. Several months afterward, Peak purchased 2,000 shares from the stock exchange. So he brought an action against the directors for deceit. Deceit means for cheating him. So it was held directors were not liable because the shares were not purchased on the basis of prospectus. Why? Because he has not purchased the shares on the basis of primary market. They have purchased the shares on the basis of secondary market. Is that clear? One more question we can cover, please. A prospectus was issued containing misstatements. On becoming aware, one of the expert, Anilesh, who had given his consent, gave a reasonable public notice stating that the prospectus was issued without his knowledge. Is it possible for Anilesh to escape liability? Tell me. Can Anilesh escape liability? This is the question in front of you on the screen. I want all of you to answer me. What will happen in this case? Can Anilesh escape from his liability? He has given a public notice. Can he take this kind of escape from his liability? What do you understand? And children, don't worry. Many of you might be thinking that we have done too much information. Revise it, relax, read it. On 16th, again, we are meeting. We'll revise each and everything what we have discussed today. I understand prospectus needs lot of revision also along the way. So we'll be doing number of MCQs. We'll be doing number of question and answers based on the content that we have done so far. And then we will move forward. Yes, children, I'm waiting for your answer. Anilesh will be held liable or he can escape. Very good. Those who have answered yes, ma'am, he can, because he has given a public notice. Because he has given a notice, not liable since he has given a public notice. Excellent, excellent. All those who have given the correct answer. Let's read. It says section 35, and no person will be liable if he proves that the prospectus was issued without his knowledge, or and on becoming aware he has given a public notice. I just explained you that defense ka second wala point. If he has given he falls under the above exception, he has given the public notice, he will escape from his liability for the misstatement in the prospectus. So we have 5-6 minutes more left. Now I give you the time for queries. Anyone wants to ask? Hardik was waiting for me to say so that we can raise hands. Anyone from the portal, if you have any questions, first you can also ask. You can ask the queries, children. I hope you enjoyed today's session, and I still wanted to do certain MCQs, but now I'll have to wait for the stream. Okay, yes, Hardik.
Ma'am, two doubts. Ma'am,
Okay.
first one is, ma'am, is there any difference between criminal liability and civil liability?
Okay. And
And
second one.
and ma'am, second doubt is that, ma'am, in the personal liability for the intent of defraud, in the case of a civil liability, ma'am, will there be section 447 liable?
Yes, okay. I forgot to show you that personal liability point. Thanks for reminding me. I wanted to show you this personal liability point also. It says where you have actually done the fraud and it has been proved. See, it says where it is proved. There is no limit of liability, means it becomes unlimited liability. So personal liability will become only if there is an intention to create a fraud and it has been proved and any loss and damages should have been. Then it will be an unlimited liability. All right. And regarding your civil liability point that you're asking, it is, see, you have to understand section 34 is trying to tell you that if you have omitted, suppressed, untrue statement, then criminal liability will come into picture. Civil liability is telling you, section 35 is telling you, if a person who has subscribed to the shares on the basis of misleading prospectus and suffered loss, you will pay damage. In both the cases, 447 is anyways going to come.
Okay, ma'am. Thank you, ma'am.
Okay, thank you, beta. Shahid, yes.
हेलो मैम.
Yes, beta.
मैम मुझे डाउट था एक्सेप्शन और एक्सेप्शन टू लायबिलिटी फॉर और गिल्टी सेक्शन 35 सबसेक्शन 2 में.
You want me to
Point,
open
last
it?
point
Which
में.
one? You want me
Yes
to
ma'am, yes
open it?
ma'am, yes ma'am. Yes
Okay,
ma'am.
which one?
No, the third one, C point.
Okay. He has made a
Yes ma'am.
statement on the basis of authority of an expert whom believe. Okay, so you remember section 26 of prospectus that we have done, that contents of prospectus and expert statement can be included. So that expert can be a CA or CS or valuer. He will give his consent and he should not have withdrawn his consent. Now, Harleen ma'am is the director of a company and my expert has given me his consent that, look, ma'am, your prospectus is absolutely fine. And he has not withdrawn his consent. Now, he is an expert. I am a director of a company. I'm relying on his statement, whatever he is telling me. And he has not withdrawn his consent, means he's still saying that whatever he has said is correct. It is true. So if you are relying on expert statement and this expert has not withdrawn, means अभी भी उसका consent वहां पर है, वो इस बात पे सहमत है, तो आप उसके ऊपर रिलाई कर रहे हो, तो फिर आप अपने लिए एक्सेप्शन ले सकते हो, आप डिफेंस ले सकते हो, आप अपने आप को प्रोटेक्ट कर सकते हो. ठीक है, आप बोल सकते हो कि मैंने तो उसके ऊपर रिलाई करा है, दैट्स व्हाई आई शुड नॉट बी हेल्ड लायबल. ओके साहिद? ओके, यस पूजा.
मैम सेक्शन 34 के अंदर मतलब मिस्टेक से लॉस हो या ना हो तो भी उसमें मतलब 447 एप्लीकेबल हो जाएगा, लेकिन सेक्शन 35 में लॉस होना जरूरी है, ऐसा है ना मैम?
Beta, 447 will be applicable if you have done any kind of untrue statement. And next class में जब हम questions करेंगे ना बेटा पूजा, और ज्यादा आपको क्लियर हो जाएगा अभी कहाँ पे एप्लीकेबिलिटी आ रही, कहाँ पे नहीं. क्वेश्चन आंसर्स में ज्यादा क्लियर होगा. अभी जो हमने आज करा है वो रिवाइज करना है, लर्न करना है. इसकी एप्लीकेशन हम नेक्स्ट क्लास में करें. ओके?
ओके.
Yes,
Sahid, you want to ask anything more?
Yes ma'am. अभी जो आपने बताया इस केस में डायरेक्टर ने तो बता दिया कि मैं अपने एक्सपर्ट के डिसीजन या फिर कंसर्न के ऊपर डिपेंड था, तो उसने अपना विड्रॉ नहीं किया, तो इस केस में मैम उसका एक्सपर्ट लायबल बन जाएगा.
Then you again have to prove that point. How expert is liable, that is not explained over here, that what kind of actions you're taking against him. Okay, but here director, or what kind of remedy that you are taking, you will not be held guilty under section 35 if you prove that. Actions will be taken against
Okay.
expert. How they will be taken, that is a different story.
Okay, thank you.
Okay. Yes, Hardik.
Ma'am, you gave an example of audited financial statement of an expert. Ma'am, but audited financial statements only gives us a reasonable assurance. Then, ma'am, and it is clearly stated by the auditor that we have done it on the sampling basis. It need not to be relied upon fully.
So you're going to the disclaimers that the auditors have given our audit report you're discussing with me.
Yes,
So what happened is, what he's trying to tell you over here is, again, let me show you the exact wording and the points that you have taken. Here, the director is just trying to take a protection. He's just trying to cover himself. We have the reasons to believe. See, children, law cannot be read on the basis of a single point or just, one kind of statement. You have to read it at length, at whole. So where is it having the reasons to believe? Okay, let me open it in my presentation where I have written it out. Huh? So where he's just simply trying to tell you that what defense I can take. If the person proves, see, this is a very important point, the burden of proof. Now, where I have the reasons to believe, my auditor has given this report. I am the director of the company. I had the audit report as an evidence. I'm showing it. Everything has to be taken in consolidated. You cannot say a single statement, yes, ma'am, auditor report में लिखा है तो हमने कर दिया. No, you have to prove it. Court will ask, कानून पूछेगा, क्या गवाह है, कैसे प्रूव करोगे, एविडेंस क्या है, how will you do it? So all these things let the burden on their head. You just simply remember what defense we can do. How to prove it, what happened, and who was held liable, how expert was taken, how you went to his home, how you picked him. Don't go into that. Simply remember that this is the kind of defense that we all can use. Material, immaterial information, ठीक है. There can be something which can say that the name cannot be, the name can also be the material information. So you have to prove it. You have it lies on your burden of proof lies on. Okay. So this is your thing all about. So I hope everything is cleared. I hope nobody no query on the portal also. Thank you, Supriya. Thank you so much for lovely words. Thank you. Nanda is asking issuing house in 6 months concept. So Mr. Nanda, deemed prospectus tells you two things. If you have issued the prospectus within 6 months, allotment of securities have happened within 6 months of the agreement that you have made with the issuing house, or the consideration amount has not been received. If any one of these things have happened, then the document through which you have offered the securities shall deem to be the prospectus. Okay, Mahima, we will check at the admin and you will get all the notes. Don't worry about that. All right, students, I cannot see any more queries, so I hope you have understood. Yes, Ms. Khushi Gupta, public notice has been given, then he will not be held liable. So thank you very much, students. My humble request to all of you, please revise what we have done. Sanya is there. Okay, Sanya. Please revise whatever we have done in today's lecture, and 16th, we'll be revising it again in the class along with the MCQs, and we will be proceeding to further sections. And also revise section 23 to 27, 29 notes. We'll be revising, we will be doing questions from them also. Yes, Sanya, last query, and then we are off for the day.
Ma'am, in section 31, it is mentioned that prospectus is issued at first issue.
Yes, prospectus.
Ma'am, but in how many days it will be issued?
It will be valid for 1 year.
But in how many days it will be issued?
In how many days?
ROC को कब तक देना था? To ROC.
Share prospectus before issuing it for 1 year. You have to file it with the ROC. Okay. So again, your contents.
And within how many days?
Child, before you issuing the prospectus, you will have to file it with the ROC. So tomorrow I'm going to fill the contents of the prospectus. You can refer to that along with this. Okay. So I'll take up in detail in the next class. Just remind me the same query. All right. All right. Thank you so much, everyone. All right. Fine, Sanya. I've seen your answer. Okay. Thank you so much, children, and see you all on 16th. All the best.